Thank you all for coming tonight. My name is Lori Burgeshausen, and I'm a member of the United Athens County Tenants, or UACT. UACT is a countywide grassroots organization that works on housing advocacy, policy initiatives, and sharing educational information about tenants' legal rights. UACT also works on projects such as a monthly eviction outreach where members send resources to individuals listed on the eviction docket, as well as hosting informational webinars just like this one. I would like to inform you that this event will not only be located on Zoom, but is also being streamed on UACT's Facebook page and will be posted online after the event on athenstenants.com if you have anyone in your network who is interested on viewing these resources. Tonight's event will begin with a presentation from Peggy Lee from Southeastern Ohio Legal Services. Peggy will talk about legal protections for people who have experienced harassment by a landlord. Then we will hear from Renee Red from the Survivor Advocacy Outreach Program and Kelly Cook from My Sister's Place about the services and support their organizations offer. Advocates from the Survivor Advocacy Outreach Program will be available throughout the event to speak confidentially one-on-one via the Zoom chat. The advocates are Renee Red and Natalie Alvarez. Renee, is there anything you would like to add about this service?
Yeah, so folks can direct message myself or Natalie Alvarez on this platform. They're also more than welcome to email or call or text us. And Natalie, if you want to put our contact information in the chat, that would be great. But I believe I'll be waiting till later to share more extensively about our resources.
Wonderful. Thank you so much, Renee. We'll be beginning with a presentation from Peggy Lee. Peggy Lee is a senior staff attorney with Southeastern Ohio Legal Services, or SOLS, in the Athens office. Since her start with SOLS in 1996, she has specialized in private and subsidized landlord-tenant housing cases, as well as foreclosure defense cases. She is currently the SOLS Housing Team Leader and co-chair of the statewide Housing Task Force, comprised of members from all legal aid programs in Ohio. In addition, she is the testing coordinator for the Appalachian, Ohio Fair Housing Enforcement Project, serving more than 30 counties. We appreciate you being here, Peggy. We're excited to hear all of the information in your presentation, and feel free to take the reign when you're ready.
Okay, thank you so much, Lori. I'm very excited to be invited to speak to everyone tonight, especially, and thank you to UACT for protecting all of Athens County's tenants. All right, so I'm going to go ahead and share my screen. Hopefully you'll all be able to see it now. Okay, great. Just to explain why SOLS is not on this slide set, these are some excellent slides that HUD has used for training purposes, and due to the rules that govern use of their material, we are not I have to keep them intact in terms of the content. So that is why our logo is not on them, but the information is still valuable nonetheless, coming from us as well. Okay. All right, so let's go ahead and get started. Let's see if there we go. So in tonight's training, this is an abbreviated version because I know there's lots of important information that Kelly and Renee will also want to be talking to you about. So it's going to be abbreviated. We're going to try to explain to you how sexual harassment and other forms of harassment violate the Fair Housing Act. We will endeavor to try to inform you about your rights as a tenant to have secure housing without harassment. And we will have a couple scenarios to go over to kind of, whet the palate to see what you think about fair housing violations. And then steps we can talk about as far as what you can do to protect yourself or give information to protect people who are tenants. All right. So essentially, the Fair Housing Act prohibits discrimination in housing based on 7 protected classes, which are on the screen: race, color, religion, sex, meaning gender, national origin, familial status, or disability. Ohio state law adds military status to the list. It also prohibits retaliation by somebody who may have made a complaint based on discrimination under the Fair Housing Act, or if somebody assisted somebody with making a complaint. Okay. So although we are going to focus tonight mainly on sexual harassment, I do want people watching to be aware that fair housing law protects people from harassment based on these 7 protected classes. And because Southeastern Ohio Legal Services operates the Fair Housing Enforcement Project as well in-house, we also take intakes on discrimination complaints. So please, if anyone watching, even if it's not a sexual harassment complaint, please, if anything happens to you or somebody you know because of either race, color, religion, national origin, familial status, or disability, our information will be shared. And please, call the office to see about getting an intake done. All right, so pretty self-explanatory. Your landlord is not allowed to sexually harass you. There's no ifs, ands, or buts about it. Your landlord must also ensure that your housing is free from discrimination or harassment by others. And if they become aware of harassment, they need to take steps to protect you from harassment that has been complained about. Landlords, if anybody in the audience are landlords, you should endeavor to also have enforcement or establishment of anti-harassment policies. And also, you should be taking action if tenants complain about harassment or when you become aware of it. For tenants, you have the right basically to complain and have the harassment stopped. Okay. Sexual harassment can come in different forms under the Fair Housing Law. It can take the form of unwelcome advances, requests for favors, quid pro quo, or other verbal or physical contact that is sexual in nature. It can also take the form of offensive remarks using sexually derogatory names or slurs at a tenant. It can be considered a violation of the Fair Housing Act. If it's gender related, it can be definitely considered as a fair housing violation. It can be verbal, it can be written, or it can be nonverbal conduct as well. It does not require actual physical contact to be a violation of fair housing rights. If anybody has any questions, please feel free to put them into the chat. And I think Q&A will be towards the end of tonight's session. All right, so here are some examples of illegal conditions being placed on housing. So in the situation where a landlord or an employee or agent, which includes local manager on behalf of a owner or a maintenance person, any employee of the owner of the premises, if they determine how services are to be rendered based on whether or not you submit to unwelcome advances or demands for either sex, sexual favors, or other sexual conduct, that would be considered a violation of fair housing law. Here are some examples. I don't know if any of you have had this happen, but if this sounds familiar, please, by all means, reach out to Southeastern Ohio Legal Services. There may also be, some support tonight if, you are currently undergoing such harassment or have been the victim of such harassment. We definitely want to know because we know it's happening. We've heard stories, but we definitely need people to come forward and be courageous to file a complaint. All right, so there have been times where we know of landlords who will send photos, or that in the case I actually had a case where a landlord sent explicit photos to a tenant who was behind in rent. We filed a Ohio Civil Rights Commission complaint based on that, and we got a resolution as a result. It went into mediation, and we had a conciliation agreement. So if any of you watching tonight have had some unwelcome advances or photos, or if you have a maintenance man who requests favors because you need your leaky sink fixed, definitely let us know. The biggest one is in today's COVID situation and losing hours at work or losing employment, being behind in rent can put people at risk of this kind of harassment getting worse. So please reach out so we can help. The other type of harassment that is considered a fair housing violation is one where there's a hostile environment. So this is where the landlord or his or her agent or employee engages in severe or pervasive or both unwelcome conduct, sexual conduct that interferes with their ability to enjoy the premises or services at their housing location. Here you could have a landlord that continuously makes unwelcome, lewd, lascivious comments about a tenant or about somebody at the location. Maybe they're describing something else. It doesn't have to be the actual tenant, but the example is there. Or unwanted touches, touching of the shoulders, touching of the hair, whatever. There's could be a whole lot of ways it shows up. Anything that's unwelcome, should be considered something to note for possible complaint purposes. And then here, a maintenance man repeatedly sends unwelcome texts. I know a lot of our clients communicate with their landlords by text, and that does set up some interesting conversations. So if you, as a tenant, have a landlord or a project manager, property manager, maintenance person, or other employee of the landlord sends you unwelcome, explicit texts, definitely, it's definitely time to submit a complaint. And by all means, keep those texts. If you have to, screenshot them. Do whatever you can to preserve any kind of evidence. Or if, we were talking about it earlier, if you think that proof may be an issue, if it happens again, I know a lot of our clients have cell phones ready at the go. If you're able to surreptitiously turn on the recording button, that may be helpful, especially if it's all verbal and not written down. Okay, so both of these types of harassment that we just discussed will violate the Fair Housing Act, and it's very common for both types to happen by a landlord or his or her employees. Your rights are the same, regardless of the type of harassment, and the landlords or the employees must take steps to protect you from either type of harassment. And this can happen not only to females, but it can happen to males as well. And I think, we may have had some complaints over the years that have affected male tenants, not just females. But by and large, we do see a much more disproportionate number from females, unfortunately. Okay. So we're going to go ahead and talk about Jane, John, and the Terrace View Apartments. So here is the hypothetical, and I would like to have some participation if possible. And I don't know if that means you can turn on your mic or typing in the chat, and I might need help with people telling me if people are typing in the chat. Let's go to the next slide. Go, oops. All right, so here we meet Jane. Jane lives in the Terrace View Apartments, where she rents an apartment with a voucher. Now, it doesn't have to be a voucher. This presentation just happened to be for people who were on vouchers or in subsidized housing, but this can be for private housing as well. So Jane gets a leaky sink and asks for maintenance to be done, submits a request. Okay. Next, here comes John. John, the maintenance man, responds. When fixing the sink, John says, Jane, do you have a boyfriend? Jane says, none of your business. He says, well, you are really hot and we should hang out. Jane says, no way. So what do you think? Do we have a fair housing violation? What do people think? Any thoughts? Okay, well, if no comments.
Would it depend on what happened next? Maybe if he continued to pursue her?
Okay, very good. So now we have another incident. Jane still has a leaky sink, and she does another maintenance request. Here comes John. John says, too busy, but if you want to hang out, I'll find the time. Jane says, sorry, I don't want to hang out with you. John says, too bad, hangs up. But there's still a leaky sink. What do you think now?
We have Nick in the chat that said that's definitely unprofessional and it's harassment.
Okay, well, regardless of professional or not, is it harassment that rises to the level, as we talked about, for a fair housing violation? What do you think?
And then we have another person in the chat that says, I think she made it clear. He's not committed a violation until he makes a quid pro quo. He is over the line.
Okay, so yes, the moment he has said that's too bad and refuses to do anything about the sink, yes, because there are now illegal conditions by delaying the repairs due to her refusal of his unwelcome advances. All right, well, good job. That wasn't so bad, right? Are there any other comments? Any questions so far? No? Okay, well, let's continue then. Jane and John, certainly a soap opera over there. All right, so more than a week after Jane spoke to John, John, who has a master key, decides he's going to enter her apartment late at night without notice and without knocking. Jane is, however, home and is startled. He tells Jane, well, I'm here to check on your sink, but he never told her that he was coming by. While he's in the kitchen, John touches Jane on the buttocks, points to a photo of Jane on the fridge and says, wow, you look hot. You should put on that bikini for me now. Jane refuses and tells John, you need to leave. John responds, just kidding. And don't you need me to fix your sink? Jane says yes, and reminds him that the sink had been leaking for over a week. Do we have enough?
There's a comment in the chat that says, absolutely a violation. She should call the police now, in all caps.
Okay, well, yes, notwithstanding the trespassing that may be happening, although she did, it sounds like let him in to possibly fix the sink. All right, let's go on and do a little bit more digging about the behavior. John makes the repair, hurrah. But then, instead of leaving, he sits down on her couch, motions for her to join him, and says, well, let's chill, watch a movie, have a little sleepover. Jane says, you need to go, and says, well, I got to get up early in the morning for work. John slowly gets up and leaves, or as he's leaving, says, you sure you don't want to call in sick? I promise you a good time if you do. Jane says, nope, you need to go, and closes the door. She then complains to her landlord about John's comments and in fact that he entered her apartment late at night without notice. Okay, let's see. Oh, well, I gave it away. So where do you think the violation occurred? What happened? So we have somebody who, we had an earlier comment, which was good. He came in and, well, call the police was the directed. But other than that, do we have a fair housing violation now? And you saw the slide, it's yes. But what made it a fair housing violation? Let's talk about that a little bit. Do you think we have a hostile violation or a hostile environment violation here? Do we have pervasive, continuous, unwelcome advances? Any thoughts? Okay.
We have people saying yes, especially with not giving notice before arrival. And then another person said he entered without notice and he is outside normal hours.
Okay. All right. So yes, he did in fact violate the Fair Housing Act. This is a hostile environment type harassment where he repeatedly commented on her body, touched her, and continued to deliver unwelcome advances, which she rebuffed. So it was unwelcome, severe, or pervasive, or both, and interfered with her ability to enjoy her premises. So that's another type of harassment, which is the hostile environment. So you have illegal conditions being placed. That was the first instance, which was the quid pro quo. And then here we have the hostile environment situation. Both of these are violations of the Fair Housing Act, but you don't have to have repeated events. A single act can be sufficient if it is severe. So touching of the buttocks here is apparently enough. Okay.
And then Peggy, we have two kind of comments, maybe questions. One is he's trying to negotiate favors. He's in trouble with the law and will probably lose his job. His employer is also at risk if not training their employee.
That is true. So landlords should, and really, make sure that they have anti-harassment policies and that they are being followed, because there is potential liability as the employer, because the maintenance person, for example, if they are not following company policy, it is potentially the case that the owner or the landlord could be vicariously liable, as since the maintenance man acts as an agent of the landlord. So there could be some liability that carries through. So definitely I would strongly recommend that for all of you tenants, you may be in current housing, that's okay, but let's say you're about to move. Make sure your next place has anti-harassment policy. See if you, before you sign the dotted line, make sure you read the lease and see what policies they do have. You want to make sure that they adhere to fair housing policies and have something that you can later enforce if need be, or contact souls with, so that we can look into some sort of enforcement.
And then Peggy, we have another comment that says, what if the tenant flirts back because she is 3 months behind in rent and is afraid of getting evicted?
I would say, it depends on her. Well, I think she should still file a complaint, because the initial behavior by the person, the maintenance man, or who, I guess John in this case, was unwelcome. And, especially if it was a late at night scenario, who knows what she may be fearful of. This could be a situation where, especially if it's a small person versus a very large person, maybe they're just trying to do whatever they can to not have anything happen to them and trying to get them out the door. I wouldn't necessarily say that makes it a non, what's the word I'm looking for? A non-actionable claim. I would still encourage the tenant, despite any, yes, I'm sure the response by the opposing side would be like, oh, I thought it was, consensual. But, if there's an explanation, I think it can be, I still think that a complaint can be filed. I would not fear a complaint. Now, I can't say that the OCRC or whomever would definitely see things 100%. It depends on the evidence, but that is why, as we were discussing before, if it is a maintenance person, for example, put it in writing and file a complaint, keep a copy so that there is some sort of record. And keep a journal. If this is something that's been repeatedly happening, just write down everything that's happened. Keep a running journal of contemporaneous notes. That could be seen as giving credibility to recollections if it forms the basis of a complaint.
Peggy, can I jump in on that one as well?
Yeah, go ahead.
And remember, there's the two different types of violations, right? So there's the legal conditions and there's the hostile environment. So Lori, it might be a little bit harder to defend the hostile environment if, it wasn't clear that the tenant, that those advances were unwelcome. However, if anything was premised, continuing to stay in the apartment, not being evicted, having things fixed, if any of that, was conditioned upon, receipt of some kind of sexual advances, then that would be clear regardless of whether the tenant flirted back. That is a strict violation there. So I think it'd be easier to prove in that first category. The hostile environment is always a lot more like fact-based. So yeah, I agree with Peggy there. That one's going to be a little bit more complicated with the flirting back, but we can sell, Peggy mentioned the client we had that received unwanted photos, and the client was actually like polite about receiving them, wasn't really clear, like, don't send me these. But it was still clear that just kept sending them without, the tenant didn't say stop necessarily, but it was still inappropriate and just kept happening. So we were able to, argue that it was pervasive, even without the tenant saying explicitly, I don't want you to send me those pictures. I think, there are some photos you don't want sent to you.
Yeah, and in fact, it could be a way to gather more evidence too, especially if somebody's recording. I'm not saying that they're trying to necessarily entrap, but there could be explanations put that way. It's not well, that throws out the whole case. Yeah, I wouldn't say it's a fatal situation.
Thank you, Peggy and Lucy. And for those who don't know, Lucy Schwally is also a staff attorney at Southeastern Ohio Legal Services.
Any other comments? Questions?
We do have one. It says, is it legal or beneficial to post a recording of landlord harassment on Facebook?
Well, Lucy, I guess I think I'd probably, well, let's put it this way. I think it might be better served for a potential complaint, not necessarily to distribute it. That's just my thought. If you want to preserve evidence for a potential complaint, I don't think necessarily putting it on Facebook is helpful. I know that's the first instinct that people might have, is to, but the problem is this. First of all, if you want to use it later as evidence, that might compromise the case. It might compromise the facts. The other thing is, you don't necessarily want the opposing party to know that you have this information if a tenant wishes to file it as a complaint. And having that smoking gun is helpful. I'm just not a proponent of putting stuff up on Facebook, but that's my personal opinion.
My response would be, Ohio is a one-party record state, so it is not illegal to record somebody. I do not believe it would be illegal for you to post it on your Facebook. Strategically, however, it might not be the best choice. I will say, though, Peggy and I are looking at this with legal hats on, of like, how is that going to help or harm your complaint you might make with an agency? Obviously, there's other considerations you make in, what we can say is it could be harmful to a future complaint you would make with a agency such as OCRC or HUD. If that is not what your interest is, if that's not how you want to deal with your claim, it might be the right choice if all you're looking for is, or you're looking for a community response or something like that. So.
Yeah, I don't know what putting it on Facebook gets you, unless.
Yeah, and we always have to tell our clients as well, like, if you want to stay, unfortunately, like, retaliation exists with landlords, right? We all have to acknowledge that reality, right? That, and especially for a tenant who does not have a year lease, so say they're on a month-to-month lease, it makes your housing situation precarious. So anything, I imagine a landlord would not like their harassment posted on Facebook, which may lead to you getting a notice to leave the premises. So.
Yeah, of course we would, if you had the need, you can always contact our office if you should find yourself in such situation. But yeah, I'm not so sure it'd be the best thing. And I don't know, there could be repercussions, not only just eviction, but, you know, is there possible defamation issues? I hope that answers the question.
And there are
Thank
no
you.
more questions in the chat. I don't know if you have any more of your presentation, Peggy, but you are
Let's see.
good to continue.
Oh, okay, so basically, here we have one more scenario. Although she's waiting for a response from her landlord, Jane contacts HUD, or it could be us, it could be Southeastern Ohio Legal Services, or it could be the Ohio Civil Rights Commission, which unrepresented people can also avail themselves of. And the agency then contacts the landlord, which then causes the landlord to confront Jane and says, you will be evicted unless you withdraw your complaint. So what do you think? What's your call? Do we have a claim or complaint against the landlord here?
A commenter says yes.
Okay, good job. So yes, this is retaliation. And even though here it doesn't say that she put it in, oh, I guess she did put it in writing. She filed a complaint. I would recommend that if you are the victim of sexual harassment or any kind of harassment that falls within those protected classes, notify your landlord. If it's, say, an employee, notify the landlord in writing, keep a copy, try to get something to verify the date on which it was submitted, so that if something adverse were to happen next, you have a clear timeline. Time is of the essence with retaliation claims. You need to be able to show this happened, then that happened. And I think that would definitely be helpful for tenants who are worried that, you know, it may be tough to prove otherwise. If you don't have a clear timeline, yeah, it could be more difficult, but I think it's definitely always good to put things in writing whenever possible. And then, you know, see if there's a way to verify the date, you know, get a receipt showing when you turn something in. And then if you do have a notice to leave, then you'll have a date on that as well. And of course, contact Southeastern Ohio Legal Services. Okay, so the threat of eviction would be considered illegal retaliation. Now, you don't have to go to your landlord first. You can go straight to any of these agencies. Obviously, if you're the type that would like to see if there's a resolution, go to your landlord and make them aware, but just know that it doesn't have to be in that timeline, but it would be helpful to set up some kind of clear timeline. Right. And with that, that ends my part of the presentation. Thank you so much. And I think, Lucy, I don't know if you want to talk about just quickly, or maybe after Kelly or Renee, about the possibility of a stalking CPO. I know that that's been a possible line of defense as well.
I can just talk about that briefly. So this is outside of fair housing. We have represented tenants when the landlord's harassment has risen to the level of stalking under Ohio law. And so that is, it's separate process from Peggy's, because it's really getting a protection from the landlord sort of continuous harassment in that way. I would encourage you to reach out to SAOP or my sister's place as sort of a first step in that process. But if you're looking for, help, and especially there's situations where a landlord's harassment have continued after the landlord tenant relationship is over, that may be when you would want to avail yourself of a civil protection order. Is that it, Peggy? I wasn't sure if there's any.
Well, no, I want to make sure that
Sure.
people knew that there may be another avenue, not just for housing, and having an order that, makes them stay a certain amount of feet away. From married landlord. Okay. Unfortunately, we do not take specific fact-based questions here. This is just a general informational session. So we can't answer specific questions tonight, unfortunately. I'm sorry. You are welcome. I hope it was helpful.
Thanks, Peggy, for your informative presentation. It's so important for tenants to know their legal rights. And we also understand that this is a sensitive topic. So once again, we have advocates from the Survivor Advocacy Outreach Program that are available throughout this event to speak confidentially one-on-one via the Zoom chat. The advocates are Renee Red and Natalie Alvarez. However, it might be beneficial to message Natalie Alvarez as our next speaker is Renee Red from the Survivor Advocacy Outreach Program. Renee has served as an advocate for survivors of interpersonal violence for 10 years. She is currently the Residential Services Supervisor for the Survivor Advocacy Outreach Program. Renee, I will pass it on over to you to talk about the services and support that your organization offers.
Thank you so much. So yeah, my name's Renee Red, pronouns are she, hers, and I am here today to just briefly talk about the services that we provide. Kind of the foundation of our services at the Survivor Advocacy Outreach Program is our 24-hour hotline. And that number, for those who might be watching later on and don't have access to the chat, is 740-591 4266. I almost forgot it, of course. And so folks can call that 24/7, and a local advocate will be answering that number. So someone who's familiar with local processes and who will be able to assist, hopefully, in any way that the caller needs. We also provide mobile advocacy services to our 8 and perhaps in the future 9 counties. And those counties are Athens, Hocking, Vinton, Morgan, Perry, Gallia, Jackson, maybe Lawrence. So I think that's it. And our advocates are meeting their clients or survivors where they're at. So folks don't need to come to Athens or Nelsonville, where our main office is located. And we provide medical and legal advocacy. Specifically with medical advocacy, if folks are seeking medical attention for anything as a result of interpersonal violence, including sexual violence, domestic violence, human trafficking, stalking, we can provide in-person assistance and accompaniment. As far as legal advocacy, we offer a wide variety of services there as well. So anyone who is interested in reporting to law enforcement, we can support people during that process, which means accompanying them, helping them set up police interviews if that's what they're that's the path they want to utilize. We can assist folks in getting civil protection orders for sexually oriented offenses, for stalking, for domestic violence as well. We also provide court accompaniment to any civil or criminal hearings. And that is only if that is what the survivor is interested in. However, I will say that accessing law enforcement or medical services or any formal system is absolutely not required in order to receive services from SAOP, because we realize that reporting to law enforcement or maybe going to the hospital isn't the safest option for everyone. And a lot of the folks that we work with choose not to go down that path, and we fully support that. However, if a survivor is willing to do that and wanting to do that, then we will certainly accompany them and give them all of the resources and support that they need. Specifically in regards to sexual harassment from a landlord or anyone associated with a landlord or property manager's company. We can, Lori earlier mentioned, the fact that the Southeastern Ohio Legal Services intake can be intimidating, and we totally understand why all that information is needed. And so what we can do is assist folks in completing that intake process. So we can provide emotional support. So I've had many times where survivors and I will meet up and we'll make that phone call together. I'll be sitting with them, helping them process afterwards, because understandably they have to disclose some activating information. So we'll help with that. And if folks choose to apply online, we can, provide our laptops, our hotspots if they don't have internet access, and just help them complete those forms. Additionally, we also provide emergency housing services. So we have temporary housing and more long-term housing for a different program that we're starting. However, the temporary housing is for folks who are fleeing a dangerous situation. And that can be harassment from a landlord, that can be domestic violence. And they are no authority housing units. So there's no staff in the unit. It's completely personal. However, we do have to limit it to 3 months at a time with the option to extend if we have the capacity. So I think I covered most of everything. Natalie, I don't know if you want to add anything that I might have missed.
Yeah, that was awesome listening to you. One thing, the extra county is Meigs County, and that's about it. Mhm.
I always miss one, and it changes every time too, of course. But yeah, thank you so much for having us.
Wonderful. Does anyone have any questions for either Renee or Natalie about the services or support that the Survivor Advocacy Outreach Program provides? If you do end up having questions, feel free to either privately message Renee and Natalie via chat on Zoom, or in the chat string all the way up top, there is their information, and perhaps either Natalie or Renee can put that in the chat right now so it's available, and they'd be happy to assist you in the best means possible. So thank you again, both Renee and Natalie. We really appreciate you being here tonight and sharing information about the Survivor Advocacy Outreach Program. Next, we have Kelly Cook, who will be sharing information about My Sister's Place. Kelly is a licensed social worker and the executive director of My Sister's Place, a domestic violence program providing emergency shelter, transitional housing, outreach counseling, and court advocacy to survivors of interpersonal violence in Athens, Hocking, and Vinton counties. She holds a BA and an MSW from Ohio University. Kelly has served on the board of the Ohio Domestic Violence Network for 6 years. Kelly, we're so happy that you're able to be here tonight, and I will pass the floor to you.
All right, thanks. Thanks for having me and our agency. My Sister's Place has been around a long time, 1977, but we are always, just trying to do our best to address the needs of survivors in our 3-county area. Again, we serve Athens, Hocking, and Vinton counties. We have a shelter in the city limits of Athens. It does have a confidential address. We're licensed for 11 beds. We're licensed and certified through Ohio Mental Health and Addiction Services. A little difference there than a lot of domestic violence shelters. We are a licensed mental health agency and accredited and all that good stuff. So we have licensed social workers on staff as our clinical team. We try to, again, back to shelter, 11 beds, that's for adults and children. Anyone 18 needs to be there with a parent. We have 5 bedrooms, including one that is accessible to wheelchairs and other, mobility challenges. We have a wheelchair ramp. So that's somewhat new just in the last few years. Otherwise, folks in our shelter have access to a case manager and a counselor while they're in shelter. We do have 24/7 staff. The 24/7 staff, we also have a 24/7 hotline with someone answering locally. And that's kind of the gateway to all of our services, including shelter. So sometimes people just call that hotline just to discuss what's going on, and the person answering the phone can kind of help make a determination about what services are relevant and helpful. A lot of folks don't need shelter for various reasons. So we do have outreach counseling and outreach case management for folks who don't need shelter at this time. All of our services are free, including the counseling, which can happen once, or we've had folks in that program for years. It's really just whatever that person needs. It's trauma informed. We work from a place of harm reduction, meaning we really have no judgment around substance use and abuse. Just see it as another element to the journey that folks are taking, and definitely meet people where they're at, and try to determine how substance use is playing a part in their lives. We also have a full-time court advocate, Becky Filer, who assists people with protection orders and can accompany people through the court process. She also can assist with those legal services applications. And we've been offering transitional housing recently, just trying to ease our bottleneck in shelter. We unfortunately turn a lot of people away because of a lack of bed space. So we've added some capacity there for folks who need longer than an emergency shelter stay. We have a pet program, so people who are in our shelter can bring cats and dogs. We have a kennel in our backyard to accommodate pets, just trying to reduce that barrier to services. And I think that's probably it for us. Thanks.
Wonderful. Thank you so much, Kelly. I would also like to note that Renee in the chat mentioned that another pillar of SAOP services is transportation for survivors for any of their needs related to the trauma they experienced. We are really lucky in Athens County and the neighboring counties to be able to have the Survivor Advocacy Outreach Program, as well as My Sister's Place. So thank you both for being here tonight and sharing information about your organizations and the services they provide. I'd like to open up the floor to any questions that anyone might have for either Peggy, Lucy, Renee, or Kelly in regards to any of the materials shared tonight. Once again, we will not be able to discuss personal legal situations. If you need legal representation or have a question, I urge you to go through Southeastern Ohio Legal Services intake process. The link was put in the chat, but perhaps Lucy can also share the online link as well. Does anyone have any questions that they did not get to ask throughout the presentations? It does not look like there are any questions. If you think of a question after the fact, feel free to contact United Athens County Tenants, and we would be happy to reach out to these organizations, or if you feel comfortable, reach out to any of our presenters' organizations to ask your question directly. If it is not for a, oh, I lost my train of thought. But yes, once again, if there's no questions, then we encourage the audience to share the information that you learned tonight through these presentations with your friends, your neighbors, and anyone in your network, to share the video on social media, because it is through understanding our legal rights and understanding the resources that are available in our counties that we'll be able not only to help ourselves, but to be able to help those in need and other vulnerable populations. So thank you all so much. And again, a recording of today's event will remain available on Facebook as well as AthensTenants.com for viewing afterwards. I want to say thank you once again to all of our presenters, Peggy, Renee, Kelly, as well as Lucy and Natalie. Thank you all so much, and we look forward to working with you all again.
Thank you. Hey, Caitlin, are we? Oh,
Hey,
are we off?
I think
Oh,
I
no,
just,
we're not. Oh, we're still live.
yeah, I think I'm just gonna go ahead and end it. Thanks, Peggy.
Yep. Are we done or do we need to debrief or anything? No.
I don't know how to turn off, oh wait, let me try to turn off the live stream.